Your Honors, there simply is just no support in the Victims' Rights Amendment to the Constitution or the current Victim Bill of Rights for appellate's position that this court should carve out an exception to Chapter 78 suspension of COLAs for retired public employees who are victims of crimes. The appellants claim in their briefs that as crime victims, they're entitled to more rights than other citizens or than other public employees, but that just isn't the case. The Victims' Rights Amendment and the Bill of Rights do provide certain rights to crime victims. But those rights concern how a victim is to be treated in the criminal justice system and have nothing to do with benefits that are provided under the public retirement systems. The appellants seem to rely on two provisions in the Bill of Rights. The first is the one that says crime victims have a right to be compensated for losses sustained by the victim whenever possible. That provision doesn't guarantee compensation. But further, there's no support for the appellant's argument that the compensation envisioned by the Bill of Rights included pension adjustments where the crime victims happen to be public employees. And furthermore, the Bill of Rights, they claim they have standing to bring the suit to challenge the suspension of COLAs under the Crime Victim Bill of Rights. But that provision in the Bill of Rights only allows victims to appear in any court in which a proceeding implicating the rights of the victim is being held, with standing to file a motion or present an argument on a motion filed. That provision gives crime victims the right to appear in criminal proceedings, and it doesn't give the crime victims the right to file a claim under the Crime Victims Bill of Rights to contest the suspension of pension adjustments. Just regarding his anti-alienation argument, I would just point you to he's correct that all the retirement systems have similar provisions. And in all of the other retirement systems, the law actually says, appellants seem to focus on any other process language in there to claim that somehow a legislative enactment could be included in the term any other process. If you look at the anti-alienation provisions in all of the other retirement systems that were enacted later than the one for the police and fire system, it actually says any other process arising out of any state or federal court. That provision was meant to cover things like levy, garnishing, and attachment that come from public proceeding.
Any questions? Judge Carroll, any questions?
Thank you.
All right, I think we understand both sides' arguments. Well put. I have to say the ice cream analogy was one of the most creative.